Now let's dive into other subtopic, the contract of guarantee, lien and pledge. So we'll begin with lien. This is the right conferred by law on a person who has a claim in respect of assets belonging to another person, which are in his possession, to retain or withhold the possession of asset until payment is made. This is simply a situation whereby a person is in possession of another person's property based on the fact that that person is owing him or her a certain sum, and until that payment is made, he cannot give the property back to the owner. For example, a carrier has lien on goods for freight due. Do we get that? If you are a carrier of goods, a carrier has lien on goods for freight due, because there are some dues that have to be paid for such, and if it's not paid, the carrier will withhold the possession of those goods. Now, what are the type of lien that we have? We have possessory lien, that is the right to retain goods until demand are satisfied, until the demands by the person in possession of the goods are satisfied. So once the demands are met, the owner will receive his goods back. So this can be general or particular. General, this is right arising by custom. Something that is normal, is a normal thing by custom in a particular contract to retain goods until payment is made by the owner, who may owe the person in possession. You help somebody to carry his goods to a particular location, and you are not giving that person the goods until you have been paid for the services rendered. It's as simple. So it's a general perception. Then we also have particular lien, right to retain goods until payment of any sum due to the possessor by the owner in respect of those goods. So this is a right to collect whatever you are being owned by the owner of goods before you give the person the possession, the goods over to the owner. So we have maritime lien. This right consists of the power to have a ship or cargo and certain interests realized. Then also we have equitable lien, the rights conferred by equity. When you have equal rights upon a person to have certain property applied in a particular manner. So that's lien. Now, discharge of lien. How can a lien be discharged? By payment, number one. So if payment is made, definitely the owner of goods will receive the goods. Then payment of the debt, one. Secondly, balance of account, as the case may be. So if the account is balanced, there won't be any lien again. The possessor of goods will release the goods to the owner. Then also by giving credit for the amount due. And lastly, by lawfully losing possession of the property. So there are instances whereby the owner is unable to fulfill all payments, and he or she will however lose possession of the property. The next subtopic is pledge. And pledge is a transfer of possession of goods as security for loan. So you want to obtain loan from the bank or other financial institution, you have to bring a collateral. So this is the transfer of possession of goods as security for loan. You have to pledge a particular property as a security for loan. Now, contract of guarantee. What is a contract of guarantee? This is a promise by one person to be responsible for the debt of another person. So most often when you want to obtain a loan, you will be required to bring a guarantor, and the guarantor will have to stand for you that, okay, this loan will be paid by you. You are a trusted person. And if the loan is not paid by the person the guarantor is standing on his behalf, definitely the guarantor will be the person to pay off the loan. Do we understand that? So what are the characteristics of guarantee? The parties are the guarantor, that is the person that wants to stand on behalf of another person, the creditor, that is the person that wants to obtain a loan, and the principal debtor, the person giving out the loan. Secondly, we have acceptance of secondary liability. So the guarantor has to accept he is accepting the secondary liability, in the sense that if the creditor is unable to pay his loan, the guarantor will be the one to offset the bill, the loan, to pay all the loans. Then we have guarantor must have no interest in the contract. It's not his contract, it's just standing as a guarantor, so he mustn't have any interest in the contract. Then there's also consideration. There must be a consideration for you to just use somebody to stand as a guarantor. There must be a consideration. Most often we have guarantors, people that can stand as guarantor, maybe a clergyman, a cleric, or an officer, a security officer, a security personnel, and so on and so forth. Then we also have availability of written evidence. That has to be what put down in written, to serve as evidence of you standing in for another person. And lastly, signature by the guarantor. I hope we understand today's lesson. So if you have any question, let's get back to class for questions and answer. However, the classwork for today, number 1 question, you have to describe 4 obligations of the employer to the employee. Describe 4 obligations of the employer to the employee. That's why question for 1994. And secondly, explain 5 duties of an employee to his employee to his employer. That's an error. Let me quickly change that. So you have to explain 5 duties of an employee to his employer. I want to correct that error. Is that taken? So 5 duties of an employee to his employer. I hope that is taken. So let's get back to class for work. Thanks for listening.